The Iowa Constitution does not guarantee the right to abortion. That's the new ruling this morning from Iowa's Supreme Court. We have team coverage this evening as we learn what the decision means to abortion access and the precedent it sets for future cases. Local 5's Mary Sugden is live outside the Iowa Supreme Court building, and Local 5's Larissa Leone live near the Iowa State House with reaction from state leaders. First now, Mary, what did today's ruling decide?
Yeah, Samantha, the current Iowa Supreme Court overturned a ruling that was made by justices back in 2018. Now, that 2018 ruling outlined that Iowans had a fundamental right to abortion under the Iowa Constitution. So what really got the ball rolling on that reconsideration was a group of Republicans asked the court to re-examine it after a lower court struck down a 24-hour waiting period that was put into place. That was under a law signed by by Governor Kim Reynolds. Now, the judge who struck that down cited the 2018 ruling as the basis for their decision, which means that that 24-hour waiting period now returns back to that lower district court. Now, just a few hours ago, I met here with Sally Frank. She is a law expert, a professor at Drake University, and an expert in abortion law. She breaks down today's impact. Well, Sally, thank you so much for giving up some time for us. I kind of want to start with a question that I'm sure is on a lot of Iowans' minds, which is how does this opinion, if at all, impact Iowans' access to abortion today?
It is questionable whether the 24-hour waiting period is in place or not. Other than that, it doesn't affect our rights today. What it does is leave open the ability of the legislature and governor to pass a statute to ban abortion in the coming weeks, such if the U.S. Supreme Court decision is overturned.
And I know that this is a lengthy opinion. It's 182 pages. So for those of us who are not lawyers, if you can kind of walk us through, really what's at issue here. What did the majority of justices take issue with in that 2018 opinion that ultimately led to them reversing it today?
Well, the 2018 opinion said that there was a right to abortion in the Iowa Constitution under both the clause that says you can't deprive someone of liberty without due process of law and the clause involving equality. And the basis of that in both decisions was an acknowledgement that women can't be fully free in our society if they are forced to carry pregnancies. And that what women need to be able to fully participate, to have liberty, to be equal, is to be able to control when, where, and if to have children. And taking that right away from women takes away their liberty and takes away their equality. The majority plurality opinion today rejects all of that reasoning, really minimizes the equality issue to try to claim that what we're saying is that women can't have children and be free, which is not what the earlier opinion said at all, and basically said the only way you decide if something is a liberty interest is if it's historically protected. And while an abortion was banned in the 1800s, at least post-quickening, and so the question really is it abortion itself or is bodily integrity what the issue is? And if bodily integrity is what the issue is, that is long recognized and supported in our nation's history.
And in today's opinion, we're seeing a court today re-examine a decision, an opinion by a court just 4 years ago. Talk to me about, is this a common practice in high courts, or does this kind of rank more unusual, I guess, for this window of time to exist? It's
unusual. While certainly courts overturn earlier opinions, some of our great civil rights cases involve that. Brown versus the Board of Ed in 1954, I believe, overturned Plessy versus Ferguson from the 1890s. And the laws criminalizing consensual sodomy were upheld in 1986 and reversed and overturned in 2004. But usually things have happened in between. The law on the ground has changed. The facts on the ground have changed. The only thing that has changed in the Iowa Supreme Court is who's on the court. And that leaves the court open to some people viewing the decisions not as what the law requires, but what just a majority of the court can pass. And that it's not about constitutional law, it's about the views of the justices.
And Frank tells me she really doesn't anticipate any legal challenges to this opinion that we're seeing today, but rather activism in the streets and really proposals from the legislature. Now, it is important to note that she says after a Supreme Court puts out a decision, it's typically about 3 weeks before that is made final. There is the period that could be a challenge put forward by Planned Parenthood in that window, but again, she does not think that is likely. She really sees those on both sides of this issue really turning their focus to Washington, D.C. to see what the U.S. Supreme Court decides there. Now, getting to today, we've seen a lot of battles and back and forth from the Planned Parenthood of the Heartland as well as from the legislature. Also, a major shift in the justices that are here at the Iowa Supreme Court.
To understand how we got here, let's take a look back at 2017 during former Governor Terry Branstad's administration. In May of that year, he signed Senate File 471 into law. That bill banned abortions after 20 weeks, put in place a 72-hour waiting period, and required women to get an ultrasound before an abortion. Planned Parenthood of the Heartland filed an injunction in response to this legislation before the governor even signed it, essentially stopping it from moving forward. 1 year later to the day, Iowa's current governor, Kim Reynolds, signed the fetal heartbeat bill. The law would ban abortions as long as a heartbeat is detected. That usually happens around 6 weeks into pregnancy, when some women may not even know they're pregnant. Planned Parenthood of the Heartland filed an injunction putting the law on pause. The next month, the Iowa Supreme Court ruled on the bill Branstad signed and Planned Parenthood's related challenge. The court struck down the 72-hour waiting period, but kept the 20-week ban. The justices also ruled abortions are a fundamental right for Iowans. At the time of that court ruling, this was the makeup of the court: 4 justices appointed by Republicans and 3 appointed by Democrats. Justices Mansfield and Waterman were the only justices to dissent to the 2018 opinion. Later that year, the court began to change, ultimately marking a seismic shift in the makeup of the Iowa Supreme Court. Justice Zager retired, replaced by Susan Christensen. Justice Hecht retired. Christopher McDonald was appointed to replace him the next year. Then in November 2019, Chief Justice Mark Cady unexpectedly passed away. Governor Reynolds appointed Dana Oxley in 2020 to succeed him. Later that year, Justice Wiggins retires and Matthew McDermott steps in. This is the makeup of the current Iowa Supreme Court, one almost completely remade by Governor Kim Reynolds, with only one Democratic-appointed justice. Since then, Reynolds has signed House File 594, which would have put in place a 24-hour waiting period. That happened in June 2020. But true to form, Planned Parenthood of the Heartland filed an injunction, essentially stalling the law. The Republican-controlled legislature in 2021 then took steps further in their goal to ban abortion in Iowa, voting to amend the Iowa Constitution. The so-called Life Amendment would make it so Iowa's Constitution does not recognize, grant, or secure a person's right to an abortion. But in order for that to happen, next year's lawmakers must again approve the measure. Should that happen, Iowans then make the final decision, voting on the measure in November 2024. In June of last year, a district court judge blocked the bill Reynolds signed mandating a 24-hour waiting period. At this point, nearly everything Governors Branstad and Reynolds signed have been struck down, including the 72-hour waiting period, the fetal heartbeat bill, and the 24-hour waiting period. A Polk County district judge ruled against the fetal heartbeat bill in January 2019. Finally, in August last year, 60 Republican lawmakers asked the Iowa Supreme Court to overturn the 2018 ruling, a likely strategic move given the court's makeup favors conservatives, with 6 of the 7 justices appointed by Republican governors.
And today's ruling was a 5-2 decision. So first, we're going to take a look at those justices who made up the majority of this opinion. So Justices Thomas Waterman, Edward Mansfield, Christopher McDonald, Dana Oxley, and Matthew McDermott made up the majority, while Chief Justice Susan Christensen and Justice Brent Apple were those who dissented to the overturning of that 2018 opinion. Live outside the Iowa Supreme Court, Mary Sugden, Local 5 News, We Are Iowa.
Mary, thank you. Some great context, helpful background on how we got here. Larissa, we go to you now. Nearly as soon as the decision came out today, Governor Kim Reynolds and others in her party calling this a victory. So Larissa, what have others been saying?
Samantha, we reached out to Planned Parenthood and they tell us that due to today's decision, reproductive rights are hanging on by a thread.
The majority of Iowans really support the right to make those what should be private medical decisions between a person and their doctor. So I think that this decision does not necessarily reflect the will of voters.
Planned Parenthood said those in support of legal abortion need to act now and call, write, and make your voices heard to public officials. Now, Iowa Pulse Advocacy Group says since 2018 ruling, their hands have been tied trying to pass legislation to ban abortion. But after today's ruling, they feel a sense of relief.
Now we can finally move forward in Iowa to protect our families and protect women who are in crisis pregnancies and have common sense regulations regarding abortion.
Pulse Life Advocate members say the back and forth of the court only shows why we need the Protect Life Amendment that will be eligible this next legislative session. Pulse Life says they will persistently continue to advocate for unborn life until all abortion everywhere is legal. Now, after the news of the Iowa Supreme Court's decision was announced, many of our state leaders shared their feelings on the decision. We'll start with Governor Kim Reynolds. She says this decision marked today was a win for Iowans, saying it's a significant victory towards protecting the unborn. Now, Reynolds says she believes every life is sacred and should be protected. She states as long as she's holding office as Iowa's governor, she vows to protect unborn children. Now, several different perspectives on this topic. Our state officials on the decision made by the Iowa Supreme Court today, and I will have some more later on in this show. Reporting live in Des Moines, Larissa Leone, Local 5 News. We are Iowa.
Larissa, thank you. So we're going to break down abortion numbers in Iowa. Data from the Iowa Department of Public Health shows that in 2019 there were nearly 3,600 abortions in Iowa, which in 2020 that rose to more than 4,000 abortions. And at the point in which women got abortions during their pregnancies, that remained about the same. In both 2019 and 2020, 95% of abortions happened during the 0 to 13 weeks period. The other 5% happened between 14 and 28 weeks.